Hi guys, it's Kathy. I hope you're doing well. We made it to Wednesday. Let's go. Guys, what a day we had yesterday. Holy cow. Okay, hi guys, it's Kathy. I hope you're doing well. I don't know why it does that. I check when I flip over, and then it flips. And I keep thinking, okay, I checked it, it's fine, and it flips. Like it's trying to help me or something. It's not helping. I'm gonna write a letter. Guys, what a day we had yesterday. Holy cow. What a freaking day we had yesterday in OJ. So everybody knows about the glove scene, the glove scene, the glove scene. But we saw it happen yesterday, and it was unfreaking believable. It was so damning. So damning to the prosecution. I mean, I have like a 2-minute video I put up yesterday of it. Now, you just can't look at the glove scene and understand what a day we had yesterday in O.J. Simpson. Holy cow. I'm still floored by it. I'm floored by how badly a trial can go in 1 second. You're cruising along fine, not really. And then all of a sudden, holy crap, one little thing. But it was huge. I don't know. There is a 2-minute video up of the gloves being put on. You wouldn't. You're just gonna see OJ put gloves on just like the rest of the world. Unless you are invested in the trial and understand everything that's going on, that 2-minute video probably will bore the heck out of you. But man, holy cow. Oh, it was bad. It was really bad. Alright. I don't know what's going on in Georgia. I don't have the next part of that trial. Hopefully I have it today. Or I won't have it at all, which sucks. Because it wasn't there yesterday, and I worked. But I didn't see it. Even at work, I didn't see it. I would have recorded it on my phone. I do have the good part, which I might show tomorrow if nothing happens. At least I can show you the good part, the stressful part. But we're going to stick with Georgia today, though. For one, two, for both judges. I have a third judge. I'll show him tomorrow. Georgia, 2 judges today. This first one I'm a little nervous about, but not really, because we watch court cases. So I don't know what this guy did, and I don't know if they're going to go into detail. But I heard the judge's speech to him at the end, which makes me wonder what the heck he did. We're going to find out together.
And if you have something different than what I say, please go ahead and interrupt me, and we'll straighten it out. We had number one was State of Georgia versus Donald Douglas, Ronald Gagney. That has been continued to the 21st.
Hi, Kelly.
Number two was Twyla Streetman. That has also been continued to the 21st. Number three, Rachel Olivia Amon, and that has been accused. Is that?
Yes, sir.
Is that what I'll show? Okay.
I think this is also a pro tem judge, retired.
Next, we have,
Which is really good news, right? People have been sitting in jail for years without being indicted in Georgia. This is another pro tem they're using to help catch up their cases. So that's good news. That's positive.
a bond hearing calendar on State of Georgia versus Corey Andrew Hardy. That came to us by virtue of defendant's motion asking for a bond modification, and the motion spelled out what modifications Mr. Hardy was seeking. This morning, yesterday, we got an email. I don't have anything other than the email. An email from counsel, Mr. Hardy's counsel, saying we will waive on Mr. Hardy. He is bonded out and in custody in Jackson County. I don't actually have a waiver, but that's what we have. Does that? Oh,
Judge Ryan Bramlett, I sent that by accident.
His shoes are his personality. You'll see.
I apologize.
Oh,
I was
okay.
meant to go to a different court. Mr. Hardy, this is just a bond modification we're requesting. He is out of custody. Unfortunately, he's running a few minutes late. I think he should be here in about 10 minutes.
okay, all right. We will, and I didn't even look, I just started reading, so sorry I had to sit through all of my blah blah when you were standing right there.
Thank you, Judge.
Cheers,
But,
Kelly.
all right,
Thank
yep,
you.
we'll get to that when we can then. And, so, then the other thing we had on the calendar was a citation matter, and that is State of Georgia versus Leah Christine Jones. Is Leah Christine Jones here? Hello, Ms. Jones. You can stay seated. I'll just I appreciate your courtesy, but I'll go through what the matter is here for. Basically, what happened is when you were charged with this offense, instead of being issued a warrant and brought to jail and booked in and done all that process, you were just given essentially almost like a traffic ticket. You're cited on a citation rather than a warrant. So what that means is that there are certain offenses where our deputies has the discretion to do that. They could have either brought you in or issued the citation, which they did. What you're here today for is I tell folks it's a string of ifs. If you are interested in clearing up your case today, then you may be able to do that. Now, I know I'm leading everything with the things that aren't positive, but you might be able to do that because there are some other ifs. The district attorney may or may not be willing to present you a plea offer to plead out your case today. So it would be a matter of if they choose to present an offer, then you can consider that offer, and if you choose to accept that offer, then we could go forward and dismiss your case. You have. It doesn't make anything any better or worse for you, whichever you decide. There's no punishment if they make you an offer, and if you decide, no, I don't like that offer and don't want to do that today, it doesn't necessarily mean that anything is going against you at that time, because you do have rights to, check with an attorney first, to run this past people to see if it's okay. Now, having said all of that, I haven't even given the district attorney a chance. I don't know if I've got her record, or if y'all have already,
So the state's not going to be extending Ms. Jones an offer. She has a pending shoplifting out of Lumpkin County
Okay.
from July of this year. So it just needs to be moved over, Judge.
okay. All right, well, basically that was the if that all the other ifs depended on. So,
Wow, Kelly, 100 bits. Thank you. Thank you for the cheers. Thank you.
this is not a wasted trip for you, because then what this will do is would replace the next time you would be required to come to court anyway. The matter will be bound over, then the district attorney's office will do whatever charge they choose to charge you with. You're not on bail or under any bond conditions right now, so that would be again, that will be something that will occur down the road, depending upon the charges that the district attorney's office does. So, having all of that, do you have any questions for me?
So today, are we just setting another date, and then we will more resolve the matter at that time?
Right. What it is, when you're given a ticket or even arrested on a warrant, that may or may not be what you end up getting officially charged with when the district attorney's office files their case. So like I say, this isn't a wasted trip for you, because this would replace the next time you'd have to come here to magistrate court anyway. So that part's done. But yes, what will happen is you'll get notice from the court if any charges are filed, and once a charge is formally filed, you'll get notice of when to appear, where to appear, and everything. In the meantime, you can either contact the public defender's office if you wish to be considered for them to represent you, or you can look into hiring an attorney on your own. So in the meantime, you can still be taking some steps to get the matter resolved. And then with your other matter in Lumpkin County, that may or may not play into how all this gets resolved. Yes, ma'am.
And Judge, I know that Ms. Jones was able to briefly speak with Ms. Willis today, and she did call the PD's office. So they're aware that her case is coming down the pipeline.
Okay, good. All right, well, it may not feel like it from where you're sitting right now, but that you're actually a step ahead of where a lot of people would be, since the public defender's office know of your situation and know that this is coming. So I think that's it. Any other, is any of my blah blah spurred any other questions for you?
I appreciate you explaining it to me, Your Honor. I just want to make sure I have any documents or who I need to be able to contact specifically. I just want to make sure I have that information
Right.
before leaving today.
Yeah, and right now there's no additional paperwork. The one thing that you really, really, really need to make sure you do is, if you change any of your contact information, address, phone number, email, anything, make sure and let the Superior Court clerk, they're on the bottom floor at that end of the building, know what your new, if any of that changes, what your new information is, because whatever they have on file, which I would presume to be, you got a copy of the ticket at the time, didn't you? Yeah. Whatever's on there is where they're going to send notifications to, unless you tell them something different.
Okay.
So, so often we'll have people, sometimes it takes a while and people kind of forget to go do that, and then they get a new apartment or a new roommate or something and go somewhere else, and the notice goes to the old address, and of course they don't show up because they never saw it, and then a bench warrant issues, and it'll complicate your life a whole lot more. So just make sure and remember to do that.
Absolutely. Okay.
And so that is it for today. You are free to go.
Okay, now I'm going to go to the case that I wanted to show you. Yep, this is it. This is the lawyer with the shoes. Here we go.
To modify some of the conditions. Are you Corey Andrew Hardy?
Yes, sir.
All right. And did everything I just said make sense to you?
Yes, sir.
You know what we're here for? All right. And you indicated at your first appearance hearing that you understood what the charges were, so I'm not going to reiterate all of that. And
I know it's domestic violence. I don't know if there's children involved. That's the only thing that's making me nervous about this clip, because some of the comments the judge says at the end. But his speech at the end is pretty good. It's epic. A little long, but very good.
counsel, it's your hearing. Take it away.
Thank you, Your Honor. Judge, I'm going to first call, I'll have Mr. Hardy's wife take the stand, Shay Hardy.
Okay.
Judge, is it?
Yeah, yeah, you're right.
If you'd raise your right hand. You swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
Okay. If you would state your name.
Shay Elise Hardy.
And Shay, what is your relationship to Mr. Corey Hardy?
He is my ex-husband, but boyfriend as well.
Okay, so y'all are currently together.
Yes, sir.
And y'all have children together?
5, yes, sir.
Okay, now, part of these bond conditions, there's one child that is listed in, one child that you have with Mr. Hardy that's listed in the bond conditions. Is that accurate?
Yes, sir.
Who is that?
Blakely Hardy,
Okay. And how old is Blakely?
7.
Okay. And I think right now there's a provision, we're asking the court to consider modifying that. Essentially, it says Mr. Hardy can't have contact with any children under the age of 16?
Yes, sir.
Okay. Now, Blakely, can you just describe Mr. Hardy's relationship with Blakely?
Yeah, they're like little buds. She adores him. She's a daddy's girl through and through. She really misses her dad, to be honest with you.
Okay. And she has communicated that to you?
Yes.
Okay. Do you have any concerns regarding
salty, same.
Mr. Hardy being around Blakely?
No.
Or any of your other children?
No.
Okay. Do you believe that serves their best interest?
Yes.
Now, part of the conditions we're asking for is, are you asking for Mr. Hardy to reside at your residence with the children?
Yes, sir.
Okay. And where is that residence?
In Brazelton.
Okay. So up to this point, Mr. Hardy has not been, obviously hasn't been residing with y'all?
Correct.
Okay. Now, there additionally, you moved to that residence in Brazelton in the last 6 months?
Yes, sir.
Now, prior to that time, you lived where?
We briefly lived in Jackson County.
Okay.
Prior to that, we lived in Cumming for, I believe it was like 5 years.
Now, the alleged victim in this case, did y'all live next door to that alleged victim's mother?
Yes, there's about 3 doors, it's about 3 doors down in the same neighborhood.
Okay. And who owns that house?
Mine or her, the victim,
Your house?
me and Corey.
Okay. So presently, part of this bond conditions, Corey or Mr. Hardy cannot go to that residence, correct?
Yes, sir.
Because it's prohibited.
Yes, sir.
Who's living there currently?
We have tenants living in there.
Okay. Now, in preparing for this motion, you're really requesting not Mr. Hardy to reside there.
Okay, maybe I'm wrong. Did she just say the victim as in somebody else is the victim. She's not the victim. He's not allowed to be near children 16 or under. She is not the victim because she just talked about a victim. So there's either another, Monica, thank you for the cheers, thank you. There's either another person, adult, that's the victim, or it's one of their children.
But to be able to go there to make repairs and so forth. Is that correct?
Correct. He does residential renovations for a living, and there's a few things there that need to be fixed, like the master bathroom sink, a fence, and, just odds and ends here and there that pop up when you have tenants. And with him not being able to go there,
I don't need no handyman. I fixed my lawnmower yesterday. I did. I had my son try first while I was at work, and I'm typing him instructions. And it's like, no, it's just not working. And then I came home from work tired and I fixed my lawnmower halfway. So, before I came home, when I mow my lawn, it goes brrr. But lately it's been going brrr, brrr, brrr. So, while I was at work yesterday, the grass situation had me so stressed out. I door dashed a hand pump from Tractor Supply, and I said, Anthony, go just replace the gas. The gas got old in there. Maybe some rain got in it. I don't know. Replace the gas. He couldn't. So when I got home, I replaced the gas. Now my lawnmower goes brrr, beautifully. But what I found out, which Anthony just told me, was a couple weeks ago the front tires stopped turning. So to use my lawnmower, you have to kind of hold it up in the air a little bit so the front tires are off the ground, and then push it. So I replaced the gas. That worked. Now I have to fix the tires. But I don't need no handyman. You don't need to come fix anything here. You can stay over there and beat up people there. I got this.
that makes us have to pay someone else to have to do it. And that can add up in cost, so it would be more effective for him to be able to go there and make the necessary repairs
You
on.
can
the
repair
home.
it, lady.
Now, going back to y'all's children, what ages they range from?
15 to 4.
Now, 15 and 4, has Mr. Hardy, other than this case, and you're not a witness to this case, has he ever been charged with any crimes against his children?
No, sir.
Is there anything else you'd like to share with the court?
I also wanted to say that a couple months ago, I was diagnosed with cancer. I'm currently undergoing treatment for that, and it has been extremely difficult because my mom is the only person who can help me with the 5 kids and also help me with treatment and everything else. So having Corey be able to help with the kids or just be around in general would really be beneficial, because in a couple months, I'm also going to have surgery to remove the tumor, which is then going to be rehab and everything like that to get my, strength and everything back in the arm. And not only just him being able to be a part of our kids' lives, to, be their dad and be a part of everything, it would really help me as well as I'm going through this very difficult time in my life.
Thank you, ma'am. No additional questions at this time. I'm sure the state may have some questions for you.
All right, thank you. Cross-examine.
Thank you. Good morning, ma'am. My name is Christian. I work for the DA's office.
Nice to meet you.
Just a couple of questions.
Yes, ma'am.
Could you give me the specific address of the home that you need the repairs done at?
3045 Pleasant Valley Trail, Cumming, Georgia.
Cumming.
Yes, ma'am. 30028.
Friends that also wrote them, not just the kids.
And I just want to make sure I have it. 3045 Pleasant Valley Trail.
Yes.
Okay, thank you so much. And could you give me the specific ages of your children?
15, 11, 10, 7, and 4.
And those are all your children with Mr. Hardy?
Correct. The 15-year-old was biologically mine, and Corey adopted him several years ago, so
Okay.
it is his as well.
Ma'am, have there been any prior instances of violence between Mr. Hardy and your children?
No, ma'am.
What about between yourself and Mr. Hardy?
There were in the past.
Okay, and what were those?
He shoved me.
Okay, did those end in charges being brought before the court?
Yes, ma'am.
Okay. Did you call law enforcement on on those instances?
Yes, ma'am.
Do you know if he was prosecuted for those?
What is,
Like taken to court, entered a guilty plea, did a trial, anything like that?
yes, ma'am.
Okay. Was there a no contact in place for you or your children for those times?
Yes.
Okay. Have you ever been scared of Mr. Hardy?
There has been times
Okay. And is that before y'all got divorced or currently?
before we got divorced.
Okay, and how long have y'all been, I guess, back together?
Since December of 24.
December of '24?
Yes, ma'am.
Okay.
Dumbass.
If there were instances of violence, either to yourself or your children, would you call law enforcement?
Absolutely.
No, she
Okay.
wouldn't.
No further questions, Judge.
Liar.
All right, thank you. Any redirect?
True.
No redirect, Your Honor. I do have some letters from friends and coworkers on Mr. Hardy's behalf, Judge, that I would like to submit.
But none of them are here?
None of them, that is true, Judge. None of them are here.
What's the state's position there?
I mean, I haven't had a chance to review them, so if the court will give me a chance to review them, I'd be happy to make a
okay.
determination after that.
All right.
Just even the way he
And
passes the
may
papers.
this
is
witness step down?
flamboyant.
Yes, Your Honor.
All right, thank you, ma'am. You can go ahead and have a seat in the gallery. Do you have any other witnesses?
No, Your Honor.
All right.
Oh, if I get a goat, though, I should get some chickens so the goat does not get lonely. CJ, I'm going to order a bunch of clothes for you to crochet for my goats and my chickens, which Manheim Township would never let me have. She's a user. I don't understand how you get there, Bobby. They have 5 kids together, and she has been scared of him in the past. And she's a user. I'm going to go ahead 1 minute and see what's going on. We're at 28 minutes.
Judge, I have no issue with you reviewing those. It looks like 3 of them are family members, which I understand want him home respectfully. One of them is from Miss Hardy, so you've heard her testimony here today. One is from his son, his adopted son, and his brother. I do believe that they obviously potentially have a bias because they're related to him, but the other 2 look like his employer, and the other one may be just a friend.
Okay. All right, yeah, I'll go ahead and review those.
Thank you, Judge.
Hold those up if you want.
I may approach, Your Honor.
You bet. Thank you.
Shay's mom's about to be here. I believe that. She didn't write a letter, but she's about to be here.
It's probably going to be too late.
He's trying to tell her to get her mom.
right, I'll hear argument.
Judge, can the state call a witness?
Oh, yes, I'm sorry, of
That's
course.
okay,
I
no problem.
Got ahead of myself. Go, yes, ma'am, go ahead.
State calls Investigator Riley.
You nailed it. John Travolta, that's exactly what it is.
Do you swear or affirm that the testimony in the matter pending before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you so much. And when you're comfortable, if you'll let us know who you are.
I'm Katie Riley.
And Investigator Riley, what do you do for Dawson County Sheriff's Office?
I'm an investigator at the Dawson County Sheriff's Office in the Persons Unit.
And how did this particular case make its way to you?
The adult victim in the case had come forward to make a report, and it got assigned to me.
And as part of your investigation,
Adult
did you have
victim.
the opportunity to talk to the adult victim in this case?
I did.
And what did she disclose to you?
She had disclosed the instance that had occurred with her, as well as witnessing what had occurred with Mr. Hardy's daughter.
And specifically in regards to what had occurred between Mr. Hardy and his daughter, could you let this court know what she disclosed to you?
Yes.
Judge,
she-
I'm gonna object, I'm trying to be as, object based on hearsay.
Hearsay is admissible in motions hearings, Judge.
It is, thank you. In magistrate court, yes, go ahead.
She had disclosed that she had witnessed Mr. Hardy cover the nose and mouth of his daughter until she went unconscious.
And did she say to you what their relationship was at that time? Mr. Hardy and the adult victim?
Yes, they were boyfriend and girlfriend.
And were they living in the home together?
They were.
And so did she disclose to you how the children made their way to the home? Was there like a custody agreement?
Yes, I don't remember exactly the days that they were there, but there was a split custody agreement.
And so on this, please correct me if I'm wrong, but on this particular instance, the children were at their home together? when this
Yes, if I remember correctly, she had explained that it was fall break and the children were at their home.
And so when she saw this occur between Mr. Hardy and the child victim, did she happen to tell you what the age was at the time?
I don't recall if she told me her age at the time.
Okay. Did she tell you how long that the child went unconscious?
I don't believe she told me how long. The intent was to get her to go to sleep because it was nighttime.
Okay. 1 second, Your Honor.
All right,
What the hell? I'm about
Did she
to
make
go
any
get
other
arrested in
disclosures
Georgia,
about
guys.
any other children?
She did.
Okay, and what were those disclosures?
She had explained that Mr. Hardy was often physically violent with the children, and he would slap them in the face.
Georgia,
And did she specify which
Dawson
children?
County.
I don't remember.
Okay. Were any other disclosures made in regards to children by the adult victim in this case?
Yes.
Okay, what were those?
She had disclosed that she knew of Mr. Hardy purchasing marijuana for the oldest, Jaden, the son.
Anything additional?
Not that I recall.
Okay.
Didn't they just said Jaden? Didn't the mom say Jaden was a girl and was a mama's girl? And 7? There's no way he's... Maybe she was something different like Jalen. And this boy is Jaden. Maybe.
No further questions at this time.
all right, thank you. Cross-examine?
Thank you, Your Honor. Investigator, good morning to you.
Good morning.
How are you?
Good.
Let me first
Oh, I'm in Pennsylvania. This is being streamed from Pennsylvania, which is 5:30 now.
start. Courtney is she's one of the alleged victims, is that right?
Yes.
And what is her full name?
Courtney Holleran.
Okay. Now, with respect to Courtney, the first thing she told law enforcement was that my client had put his hand over Blakely's mouth.
Blakely's nose and mouth, yes, sir.
and that it was so severe that the child became unconscious.
Correct.
Okay. Now, she did not report that day or even months later. Isn't that accurate?
That's correct.
Okay. In fact, it was 7 months after she reported that to law enforcement, correct?
I don't know the exact time frame. I just know it was not right then.
Okay. And in addition to that disclosure, Blakely never received any type of medical treatment, correct?
Not to my knowledge.
Okay. Now, did you ask Courtney why she, I mean, these are, you would agree, in investigating this over a child, that could kill a child if it was true, correct?
Correct?
In other words, the act is very serious.
Yes.
Did you ask Courtney if that was true, why she didn't report it that day, why Blakely didn't go to the hospital?
I do know that Courtney had delayed her reporting all of these incidents due to her being in fear.
Okay. That's what she reported to you?
Correct.
Okay. Are you aware, have you spoke to Courtney lately?
Not recently.
Okay. Would it surprise you if Courtney's trying to reach out to my client currently?
You're asking if it would surprise me?
Correct.
I don't know.
Okay. So she's saying she didn't report that because she was in fear for months and months and months? Is that correct?
I believe so. It was a delayed reporting.
Okay. And then the slap, there was a slap that, again, she didn't report until months and months later, correct?
Correct.
Now, I do represent Mr. Hardy on the criminal case in Forsyth County too. Are you aware of that case?
I briefly know about it. I don't know many details surrounding it.
Okay. Are you aware that Mr. Hardy was granted bond in that case?
Yes.
Okay. And because of issues with evidence, the state has not indicted Mr. Hardy on that case. Is that correct?
I don't know.
Have you met with Courtney here at your office?
She did come into my office, yes.
And how long ago was that?
That was in March.
Is one of our conditions, we're asking the court to consider modifying and allowing Mr. Hardy to go to his residence, which is 3 houses down from court.
Hell no. Send him to jail. Put him in jail. No, don't put him near those children. No. No. Absolutely not, sir. Okay, that's a little shocking that it's southwestern Georgia. If I had to put money on it, I would have said mid to north, only because their accents are there, but not there. Like yesterday, those were Georgia accents. But then you go to northern Georgia and there's hardly any accent at all. This is like closer to that.
His mother's residence. Do you know if she's still residing there?
I don't know if she is still residing there. There was discussion that she had planned to move out, but I don't know if that ever happened.
Okay. In your investigation, though, in regards to these allegations against Mr. Hardy, there was no medical records have been brought to your attention.
Correct.
Okay. And there hasn't been any pictures of any violence or pictures of bruises or any other issues brought to your attention, correct?
I do have photos. If you're referring to the children, no.
Okay, photos of, in which, if I may ask, what child?
No, I don't have any for the children, sorry. I was saying for Courtney.
For Courtney, allegations, and what are those pictures of?
Injuries, bruises.
Okay. That, again, she didn't report that till months and months later as well?
Correct.
Did she indicate, though, with respect to how I see this, it's essentially about 7 months later, after the allegations came forth, that she reported. Did she report to you during that time Mr. Hardy was not residing with her that entire time?
During the space between it happening and her reporting?
Correct.
No, they were not living together at that time.
Because one of the things you reported was why she didn't report to law enforcement.
Because that's her dad, and it's more complicated than that, sir, idiot. You make me feel like I have wasted my life. Oh, what do you do for a living? Oh, I make sure that anybody impaired can read books. And then you turn to me, what do you do for a living? Oh, I serve iced tea and lemonade.
Was because that she said she was in fear, correct?
Yes.
So obviously, if Mr. Hardy's not residing with her and doesn't have that control or alleged control over her, she should be able to report it, correct?
It's possible. I do know that while she was living at her mother's house, and he was living just down the street, they were still close.
Okay. Did she report to you that, in fact, she didn't report it until she saw that Mr. Hardy and his ex-wife were back together?
No.
All right. No additional questions. Thank you.
All right, any redirect?
One brief.
All right.
In your line of investigative work, is it uncommon for victims to delay reporting?
Not at all.
And why is that?
There are so many different reasons why victims delay reporting, one of which is being in fear, retaliation.
Thank you.
Any recross?
None, Your Honor.
All right, thank you. May this witness be excused?
Yes, Your Honor.
All right, thank you.
Thank you.
Thank you, investigator. Any other witnesses for the state?
None from the state.
All right.
I'm very worried for you right now. Only because if you want to cure insomnia, this is not a good place. because we don't sleep here. So if you want to cure this to be good at your job, this is the wrong place for you to be. We'll keep you awake.
Our mom's here now if we want to.
Did you hear that? She got her mom already. He turned around and he said, "Get your mom." And boom, he just said, "Her mom's here now." This lawyer does not want to put the mom on the stand. Did you see what he said earlier? He whispered. I couldn't hear all of it, but he was like, I just don't know what she's going to say. The lawyer does not know what the mom is going to say, but he wants him to put the mom on the stand. We'll see how that goes. I'm midday by 8:30. I'm ready to go by 8:30 a.m.
The residents, Joel.
All right, argument.
Judge, in regards to defense's request in regards to permission to perform maintenance and repairs, we actually spoke with Courtney in this, the adult victim in this case, and she doesn't have any opposition to that. So the state is amenable to that request, only for the purposes of him going over there and performing maintenance. Obviously, if he sees Courtney, not to have any contact with her, nothing in regards to Courtney would change, Your Honor. So we don't have any objection to that request. In regards to the children, the state obviously has grave concerns given the allegations in this case, specifically because one of the allegations is that he placed, and you heard from Investigator Riley, is that he placed his hand over the mouth and the nose of his, as of today's time, his 7-year-old child, causing her to lose consciousness. While I understand that we are in an allegation stage, Judge, the allegation is serious enough to warrant Mr. Hardy to not have any contact with his children. I understand that that puts this family at in a huge burden, given Ms. Shea's testimony regarding her ongoing medical conditions. Ms. Hardy also testified that there have been allegations of violence between herself and Mr. Hardy in the past. So given her testimony regarding those allegations, or those instances of violence in the past, the state does not believe that the request needs to be granted, given the fact that he has prior history of violence, that these are now new allegations of violence towards a new victim, as well as his own children, Your Honor.
Thank you. Charles?
Yes, Your Honor. Judge, these cases, at least bond modifications, they're always,
OJ was really, though, yesterday. Holy crap. That's how OJ was yesterday. Holy crap.
they're always somewhat difficult because obviously we don't have Courtney here. It's not, facts and so forth. But I will say this, though. It seems, I understand the state's position, but it seems very odd to me that these are very serious allegations against Mr. Hardy. And if they had occurred, again, I submit to the court that Courtney would have called law enforcement and so forth, and that was never done. And then what I hear from the state is, and I get sometimes victims are scared to report and so forth. Generally speaking, in my experiences, that's dealing more with the victim itself, not like a third-party child. But I believe what happened here, Your Honor, is you're talking about about a 7-month span from the time where these allegations or this incident allegedly occurred to when Courtney reported it. In the meantime, Mr. Hardy is not residing at that residence. What happens is Courtney sees Mr. Hardy with Shea, who testified here today, that they're back together. And she doesn't like that. And then after that point, she reports all these very serious allegations against Mr. Hardy. It has nothing to do with her being in fear. It's really self-preservation and wanting to be with Ms. Hardy and disrupting that particular issue. And it's interesting that Courtney is in agreement with Mr. Hardy being able to make these repairs at 3045 Pleasant Valley Drive, right where her mother lives. So I believe, Your Honor, there are serious issues with the credibility of Courtney. And I don't want to, I spoke to the state before court today, and they've been very fair and gracious, but there's serious concerns regarding her credibility in Forsyth County, and that's why you don't have an indictment in that county either. Now, Shea did report back before there has been incidents of family violence. There's been no charges against Mr. Hardy regarding the children. We're talking about children up to the age of 15. That's a long period of time. I think that's a very good track record. There is no one that knows Mr. Hardy better than Shea. And it is true, Shea's going through a difficult time. She was diagnosed with cancer. I believe her mother is here, but based on these allegations and so forth, Judge, I think more harm is done by keeping Mr. Hardy away from the children, keeping Mr. Hardy away from Shea. And I think the lack of just the issues that appear with respect to the disclosures of Courtney. So I am asking this court, Your Honor, certainly at the very least to allow him to be around his children. I can understand if there was a history of violence regarding his children. There's not a history of violence regarding his children.
But there is a history of violence.
None of that. So I'm asking you to respectfully, Your Honor, to modify that condition and allow him to to be with the children, around the children? If so, if that's what Shay chooses. I know she moved to Brazelton with the children. They've had a lot on them since these allegations have come forth. So that's our request, Judge. Thank you, sir.
All right, thank you. I do have some questions. Just so that I have all the logistics clear in my mind, the address 105 Springfield Lane, Dawsonville, Georgia, what is that address?
That was the rental that me and Courtney lived at, but I moved out of there. We terminated the lease in, I believe, February of
Okay,
this year.
so to your knowledge, she doesn't live there either?
No, sir.
Okay. And just for your protection, make sure your attorney knows what you're fixing to say, or speak to him first. I don't want you, for your protection, just blurting too much stuff out, or if I ask a question that you feel is objectionable, I'll certainly entertain that objection.
Thank you, Judge.
I'm just trying to, like I say, trying to get so as far as we know then, the 105 Springfield Lane, Dawsonville, Georgia address doesn't have anything to do with anything right now. Is that correct?
It's my understanding, Judge, and I'm sorry for speaking up. It's my understanding, Judge, that that is where Courtney's mother resides.
No.
Well, Courtney's mother resides next to that address. So they're not directly like right next door, because I
Oh, okay.
specifically asked this question.
Was
They're
that
kind
the-
of like catty across the street.
Oh, okay.
Okay, that's not what she told us.
They're saying that, Judge, and there seems to be a disagreement because the address where Mr. Hardy, and I haven't confirmed this, right?
Okay.
But this, Mr. Hardy says that address is 3045 Pleasant Valley Drive.
Okay.
That's my marital
And who lives at 3045 Pleasant Valley Drive?
That's Mr. Hardy and Shay's rental property that is 3 doors down from her mother's residence, Courtney's mother's residence.
Okay, so,
Her mom's address is Millard Way.
so the defendant and his ex live at the 3045
No.
Pleasant Valley Trail, correct?
No, Judge. That is their property that they're renting out, Your
Oh,
Honor.
okay, so, they own that property but do not reside there.
Yes,
So none of the parties to this matter reside at 3045 Pleasant Valley Trail.
correct, Judge.
All right. Now, Courtney's mother, who is also not a named party to anything, first of all, is that part correct? Am I saying that correct?
That is correct, Judge.
Okay.
Correct.
All right.
Courtney's mother is not a named party. It's just Courtney and Blakely named in the warrants.
Right, gotcha. All right, and so, so she allegedly lives nearby.
And that's on, according to Mr. Hardy, Your Honor, that's on Millard Way, which is a cul-de-sac 3 doors down.
Okay, I got you.
That's my understanding.
Okay, I just want to make sure, all right. Okay, I'm going to try and keep this straight then. In that regard then, nobody is concerned about the defendant going to that address to effect maintenance as any landlord would need to do. Is that correct? Okay.
Correct.
All right.
The no contact with Courtney obviously will stay in place.
Yeah.
Since there wasn't a motion for that. So as long as he's not having contact with her, there's no issue in regards to the maintenance of the property.
Okay. All right, let me. Mr. Hardy, what do you do for a living?
I do residential renovations.
Okay. So not only to this property, then to other people?
Yes, sir. Anything from concrete to the roof, I can do.
Okay. And do folks just contract you directly, or do you have a company set up, or how does that work?
I do have a company, but mostly it's word of mouth.
Okay, all right. All right, well, I've got, as often is the case in these kinds of situations, I've got dueling priorities. And priority one is that, on the one hand, bond and bond conditions are not supposed to be punitive because Mr. Hardy has not been convicted of any of these allegations. But then I've got to balance that with, obviously, the safety of the community and safety of the alleged victims. Give me a rundown of, you said there are 5 kids.
I love this judge, but don't love this judge because I'm pretty sure he's pro tem, and I can't get him again. And no one else is getting him because you want to know why? All of these Georgia courts are exclusive to court vibes. Just me. So.
Give me the names and ages of the kids that live.
It's Jaden.
Okay,
He's 15.
15, all right.
Ophelia. She's 11.
Okay,
Scarlett. She's 10. Blakely is 7. And Brinley is 4.
and what was that name?
Brinley?
Okay, now of those, all of those are, it's court's understanding, and correct me if I'm wrong, all of those are either biologically your children with Shay or have been officially adopted by you. Is
Yes,
that
sir.
correct? Okay. And where do these kids live?
They live with their mom.
Okay, at what address?
Monica, thanks for the cheers. Thank you. I'm going to mute it for a second.
Brazelton.
Okay, one of the items in the motion say that the alleged victims are not his children, but Blakely is an alleged victim and is your child, correct?
Yes, sir.
Okay.
And Your Honor, that was my mistake.
Oh, that's okay. That happens. I make enough in a day for 3 people, so.
I will give you 3 kids and 5 cats right now.
And here's the court's concerns. Again, Mr. Hardy, I want you to understand that I understand that you have not been convicted of any of these offenses. On the other hand, the fact that we're talking, the allegations cover 5 different dates, 5 different instances, and if there is anything to these allegations, that's what we in the justice system call a pattern, and a pattern that tells you something, a pattern that is a reliable indicator of things that go on. And the reason that's troubling for the court is pattern is exactly what domestic violence is all about. Domestic violence is power, control, fear. And we've heard elements of the possibility of all of that here. And it fits the pattern of allegations. Again, you haven't been convicted of any of these. There, as your attorney has explained, there could possibly be a reason that these allegations came to light in the manner in which they did and the timing in which they did. But there is also an equal argument that explains why those delays happened. That's also a very real part of domestic violence. Inasmuch as it's my place that it's proper for me to lecture you when, again, you have not been convicted of these. If any of this kind of stuff is going on, then this is what you're teaching your kids. Little boys who grow up around this stuff grow up to do it. Little girls who grow up around this stuff grow up to let it be done to them. I know that this is not what anybody involved in this case wants for these kids. But you can sit them down, you can lecture them, you can tell them, you can talk to them. What they go by is what they see you do. And again, I don't mean to be lecturing you as if I'm taking it as a matter of fact that you've done these things. I don't know if you've done these things. But this is scary stuff, potentially scary stuff that the court has to consider. I'd be very remiss in my duties if I just blew this off and said, yeah, it's a jealous ex dredging this stuff up. Sadly, that sometimes happens. And sadly, what these allegations say sometimes happens. And I have no way of knowing at this stage of the game where we are along that spectrum. That spectrum being these allegations are the result of a jealous ex to you've done every single one of these things that it says. And so wherever the truth is in there, I don't have any way of knowing. But a pattern is concerning to this court. The folks who have written the letters, I can't really consider Shay's letter because she was here to testify. So if there was anything in there she wanted to tell me, she should have told me. So I go by her testimony. The others that talk about you wanting to raise your kids with good values and that you want to raise your children the right way and being a dedicated dad and kids that obviously love you. I deal with it constantly. Children who are in horrible, horrible situations, but they still adore the person that's doing these things. Because that's who's there to love them and protect them and to raise them. So that's the people they know, that's the people they turn to. Shay's cancer diagnosis. You know, that's a kick in the gut for all of you, and I understand that. And on the one hand, she could use a dedicated partner to help her and support her through all of this. On the other hand, I've seen it, and I'm not I'm not imputing this to you at all, because again, I don't know the facts. But the court has unfortunately been exposed to situations where, as cruel as it sounds, people, that's one more situation where you can exert control because she needs you, because she's weakened by her diagnosis. Again, I'm not accusing you of that. I don't know that this is happening, but it's one more thing.
We'll tell you it is, Judge. It is. Zach, thank you so much. Thank you.
that I have to sit here and juggle back and forth. Are you gonna help her through this, or are you gonna use this as one more way to exert control? Because that's what domestic violence is about. Power, fear, control, and pattern. And I've got two of those things in the allegations, certainly. Pattern and fear. And power.
But I don't drink anymore.
He said it was because I was drinking and I don't drink anymore. That's what this man just said.
Two pre-trial and probation.
Here's what I'm gonna do. As we have already mentioned, got no problem with you being able to go to the 3045 Pleasant Valley Trail in Cumming. I don't, that address was never specifically in the bond order, but it would probably have fallen under just the general no contact provision. And the 105 Springwood Lane, that, as we say, nobody is there now that is party to any of this, so that's kind of moot. What I am inclined to do is grant the motion with some, of course, some conditions. What I would do is because of the way the pre-printed language in the template of the bond order, it will be easier for me to just remove number 5, that's the no contact provision, and then in item 16, say exactly what we're trying to do. The other thing that I would order, and let me ask the district attorney's office this, and I'm not trying to put you on the spot, I'm not trying to push any way or the other, I'm merely asking because I don't know the answer to this question. Do you have any idea how close you are or are not to indictment in this case?
Your Honor, I do not.
Okay.
So this case was,
What a stupid freaking question, Judge. Judge, I know you're retired, but you know what's going on in Georgia. They don't know when they're going to indict a case. Could be 2 years, could be 8 years. But we know it's not a year. We know it's not going to be 1 year from the time they were charged. No, they're a mess down there, a mess. It's criminal.
originally Mr. Hex. He's no longer with our office, so it's
Right.
been reassigned to Mr. Garner, who is currently in trial.
Yeah.
So I have no idea.
No, I got you. There's often no way. What I want to do, is if I grant the motion as requested, I would add the condition that Mr. Hardy enroll in and successfully complete the Family Violence Intervention Program. The complications to that may be, I don't know, y'all may know, I don't know who does it around here now and where it's done, but it's certainly still available to your knowledge, is it not?
To my knowledge, it is, and it's probably, he probably would have more resources over in the Flowery Branch, Hall County area.
Oh, okay.
I can ask for retrial.
Anyways.
Okay. And what this is, Mr. Hardy, just so that you know, I don't want you being blindsided by this. Family Violence Intervention Program is about a half a year long, and that's the reason I was asking about, because I don't know, I don't want to put you on some bond condition that's going to last longer than before the case is indicted, but even if and when the case is indicted, you'd still be under the same bond conditions until it came to some resolution. And if, and this is a big if, the resolution of the case involved you being convicted of any of these offenses, I would presume that that would probably be a request of the state that be a condition of your sentence anyway, and you'd be you'd be that far along in it already. It's not a touchy-feely where you sit there and you nod and look real sad, and at the end of these months, you get your certificate and that's done. You have to actively participate in the program. You have to talk about what you've done. Now, your lawyer can explain to you, how you go about doing that without incriminating yourself in the criminal case. But it isn't just a pass, like I say, where you sit there and look all sad and contrite, and at the end they pat you on the back and give you a certificate. You have to participate in this program. It means addressing things that go on, and it specifically is designed to address the matters of the things I've been talking about: fear, control, and power. And so that's what it's for. Is that something your client would be willing to do, given my very generic explanation of what it is?
Certainly, Your Honor. Yes.
All right, and then, as I say, there are, as the DA's office has indicated, there
It's not a job now. That's not a job. It's too much fun to be a job.
are various vendors and at various locations of that. So that will be, I think I've made all that clear as mud. What I'm going to do is, if you will give me, once we recess, this is the only matter before me right now. So I'll recess, I'll go back, I'll sit down and kind of type that out and make sure that I think I've got it clear in my head what I want to say. And then I can do, you are free to either you or your client or both of you are free to hang out in our lobby while I do that. I mean, I'll go back and do it right now. Or if it's taken too long and you've got other matters to attend to, or Mr. Hardy needs to get to work or whatever, then it's certainly something we can email you. If you need to get on with business and not wait on it, I'll email you a copy, and likewise with the DA, and so you can look over it and go, that isn't exactly what I thought you said, Judge, and we can fix anything that is wrong with it, or if it does comport with what you think I've said so far, then just let me know and I'll sign it. Does that sound doable?
Sounds good to the state. Just for clarification purposes, everything else remains the same except removing the no contact. He can have contact with his minor children, and then he's gonna enroll in and successfully complete the Family Violence Intervention Program.
Right.
Perfect.
And I'll replace the no contact provision with some verbiage in the other conditions paragraph that says as to Ms. Howard.
Perfect.
And Judge, I'm fine with an email copy. I know Shay has treatment this morning. They were hoping to go together after this hearing, so
Yeah.
we're fine with an email copy.
Okay, I'll like I say, I won't file it. I'll submit you an email copy to both of you, and that way you can proofread it, and because it is not unlike me to either have a typo or have left something out that we've sat here and talked about, and I'll let you look over it. And then if there are if you're both okay with what I send you, just let our office know and it'll get filed in.
We certainly appreciate it. Thank you, Judge.
All right, thank you.
Your Honor, could you include Ms. Mixon on that email?
Oh, yeah.
So that way, because I just got called into trial
Oh,
upstairs.
okay.
So she was here, she knows. I'll let Grant know also, Mr. Shope. And then that way, if someone can sign off on it for me.
Okay.
Thank
All right.
you.
Okay, I think then we are in recess. That'll be.
I like that, Judge. I like how he explained how the family violence course is gonna. I didn't know it was like half a year long. I didn't know that it was that detailed that you have to. I mean, no, they're not. I mean, so it's hard. He has to take this family violence course. To take this family violence course, he has to tell them what he did wrong. They won't let him just sit there. He has a couple criminal cases going on where he cannot admit what he did, because that's, he'll go to jail if he admits what he did. So the judge is like, talk to your lawyer. He will tell you how to go through that course without admitting something that would hurt you criminally. How is he going to do that? He can't admit he did anything wrong, but the course, I don't know, but we got more information about the family violence course from this judge than we got from any other judge. And I like how he's like, I know you're innocent, but if you did this stuff, it's pretty bad, but I know you're innocent. I don't think HIPAA applies to that, because it's not medical. I don't know. I've never been to a family violence course. Well, that's not going to work very well.
Mr. Stokes is just having to pay money to get out of jail.
No one can see that. It's too tiny. Alright, I'm going to have to fix this so we can see what we want to see. Whoops. Alright, I'm going to put it over here. Make it just a tiny bit smaller. Chat is the most important feature of this live stream by far. So we'll put chat here. I don't think they're going to play anything on the TV, but I'm not going to cover it. As long as we can see chat. I'm going to start with a real shitty case. That's going to be really funny in a second, don't worry. That joke is going to hit you later. Oh, a shitty case, I get it now. You're going to say. Good enough.
Concurrent to count 1. Mr. Wood is to pay all applicable court costs and surcharges, any reimbursement of attorney's fees. He's to report to felony probation, perform 40 hours of community service, sign a Fourth Amendment waiver, waive evidentiary foundation.
Damn it. Ah, Sherry's the black cat. I got him wrong. In my head, that's fine. I got him backwards.
He is to provide records release, complete a substance abuse evaluation and treatment. He is to provide a DNA sample, avoid all alcohol and drug use, and comply with random drug screens.
Any prior history for Mr. Witt?
Your Honor, he does have a prior history.
They're not drugs related, Judge.
That's correct,
Terry, I'm so sorry. That sucks. That sucks.
Your Honor. A couple misdemeanors. Yes, Your Honor, that's correct.
Now, the baby wants baby back ribs for lunch, so start them cooking. The last kitty I got rid of a couple days ago was the all-black one. I called her
Mr.
Shadow because she followed me everywhere.
Mr. Callahan, can Mr. Witt pass the drug screen today?
Yes, sir. Excuse me. Yes, Judge. That was a combination of yes, sir, and yes, Judge.
I have 4 tuxedos.
Witt, I'm holding here your petition to enter and plead guilty. You
They're
recognize this
different.
document? Can you read it, understand it, go over it with your attorney and sign it on the second page?
Yes.
Did you answer the questions truthfully?
Yes.
Did you sign the document freely, voluntarily, and with a full understanding of what you were doing?
Yes.
Do you understand what you're charged with?
Yes, sir.
Has anyone coerced you to enter a plea of guilty through threats, force, or promises?
No, sir.
Are you now under the influence of alcohol or drugs?
No.
Were you present when I told you the rights you give up when you plead guilty?
Yes, sir.
Have any questions about those rights or about anything regarding your case?
No, sir.
All right, Mr. Witt, then as to count 1, sale of marijuana, count 2, sale of marijuana, count 3, possession with intent to distribute marijuana, how do you plead?
Guilty.
Did you in fact commit those offenses as you've been accused?
Yes.
I'm going to accept your pleas of guilty, find you guilty, and find
That's a
that you entered your
perfect name.
pleas
Your daughter's
freely,
awesome.
voluntarily, and with a full understanding of what you were doing. Do you agree?
Yes, sir.
Mr. Callahan, you agree?
Yes, Judge.
Anything you want to say about sentence?
Yes, Judge, we would ask that you do accept the sentence as negotiated. Mr. Witt, he's been into pretty much every court date. He's been very upfront and honest about this case with me. Understand normally, I mean, this is probably on the lighter end of what Your Honor would normally impose on a cell case. But I will note, Judge, you know, he doesn't have any prior drug history. His only other history is something from decades ago. He has 2 businesses. He is an upstanding member of society. And I know 6 months with him is already going to be a little difficult due to his fiance who did have that stroke, who is currently undergoing physical rehab without the usage of insurance. So I know this is already going to be very significantly burdensome just to helping that out. So we would ask that Your Honor accept the negotiated.
Mr. Witt, this is what I'm going to do. I'm inclined to go along with the negotiated sentence if you can pass the drug screen today. But you know, I hear Mr. Callahan saying you got lots of issues, but you can't be selling drugs, not in this community. So if you can pass the drug screen today, I'll assume that this is sufficient to remind you that you can't do that. If you can't pass the drug screen, then we got some other issues we got to talk about. All right?
Yes, Judge.
So Mr. Witt can stay around. Maybe we get somebody for probation to do a drug screen, and I'll hold the sentence until see what that results in. All right, thank you, Mr. Witt.
All right, thank you.
All right, Warren Kelly.
This is the shitty case. this is Hall County, which Eileen will tell us if I'm wrong, has to be further south because the accents are delicious.
Your Honor, I believe this is going to be an open plea today. Is that correct, Mr. Sebastian?
Yes.
Your Honor, this is State of Georgia versus Warren Tamarius Kelly, case number 2025 CR 0487 JJD. Mr. Kelly has been charged by way of indictment with 1 count of possession of firearm during the commission of a felony, 1 count of possession of firearm by a convicted felon, 1 count of possession of methamphetamine with intent to distribute, 1 count of possession of marijuana less than 1 ounce, 1 count of speeding, and 1 count of failure to carry a license. Your Honor, would you like me to go ahead with a factual basis before?
Yes,
Okay.
please.
Your Honor, on or about January 3rd, 2025, officers pulled Mr. Kelly over for traveling at a speed of 88 miles an hour in a 45-mile-an-hour zone. Upon making contact with Mr. Kelly, officers smelled the odor of marijuana coming from the vehicle. Mr. Kelly told them that it was in the center console. He also stated that there was also meth and drug paraphernalia in the car. When officers searched the car, they found less than 1 ounce of marijuana. They also found a small plastic container that contained 6 small bags, each with a white crystal-like substance that ended up being methamphetamine that was confirmed by the crime lab. And they also found a black Smith & Wesson .45 caliber handgun. And from the crime lab, that total weight of methamphetamine was confirmed to be 15.44 grams, Your Honor. So the state is seeking for count 1, possession of methamphetamine with intent to distribute.
I'll tell you what, let me take the plea and then I'll hear,
Yes, Your Honor.
hear your recommendation.
Yes, Your Honor.
All right, Mr. Kelly, I'm holding here your petition to enter a plea of guilty. You recognize this document?
Yes, sir.
Did you read it, understand it, go over it with your attorney and sign it here on the second page?
Yes, sir.
Did you answer all the questions truthfully?
Yes, sir.
Did you sign the document freely, voluntarily, and with a full understanding of what you were doing?
Yes, sir.
You understand what you're charged with?
Yes, sir.
Has anyone coerced you to enter a plea of guilty through threats, force, or promises?
No, sir.
Are you now under the influence of alcohol or drugs?
No, sir.
Were you present when I told you the rights you give up when you plead guilty?
Yes, sir.
Have any questions about those rights or about anything regarding your case?
No, sir.
All right, Mr. Kelly, then as to count 1, possession with intent to distribute methamphetamine, count 2, possession of a firearm
Wait, are you saying Hall County is up north? Sherry, is that what you're saying?
during the commission of a felony, count 3, possession of marijuana misdemeanor, count 4, speeding, count 5, failure to carry a license, and count 6, possession of a firearm by a convicted felon. How do you plead?
Guilty.
Did you in fact commit those offenses as you've been accused?
Yes, sir.
I'm going to accept your pleas of guilty, find you guilty, and find that you entered your pleas freely, voluntarily, and with a full understanding of what you were doing. Do you agree?
Yes, sir.
Mr. Sebastian, you agree?
Yes, Your Honor.
All right. I think the state gets to go last in argument, but if you want to make your recommendation, I'll hear your recommendation, and then Mr. Sebastian can go, and then you can argue if you have anything else to argue.
Yes, Your Honor. As to count 1, possession of methamphetamine.
That noise is someone with a pen, I think. And if I had to guess, if I had to put my hard-earned money down on who is the woodpecker, I would say it's his attorney. I don't think you can see my mouse, which sucks, But to the right of the screen, there is an inmate. To the left of him is his attorney. If I had to put money down, it's that guy right there. Right there.
With intent to distribute, the state is seeking 20 years with the first 6 years to serve, the remainder on probation, and a $2,500 fine. As to count 2, possession of firearm during the commission of a felony, state is asking for 5 years on probation consecutive to count 1. For count 3, possession of marijuana, that's going to be 12 months on probation. For count 4, speeding, is another 12 months on probation. As to count 5, no license on person, that's a $25 fine. And for count 6, possession of a firearm by a convicted felon, the state is requesting 5 years to serve concurrent to count 1 for a total sentence of 25 years with 6 years to serve. And all other
Mr. Sebastian.
conditions.
Your Honor, I've learned that Mr. Kelly had a previous history in the drug court program, I believe, so he's had some issues with drugs in the past. This is a possession with intent case, but I do believe that, just sort of drug use has been an issue in his life. So my recommendation would be, I guess, 12 months, and then after that would be for him to enter into the RSAT program. I don't, obviously, drug court, especially with him picking up these charges so close after his drug court graduation, we'd normally not like to see that, but I would like to have him try RSAT, see if perhaps that might be able to, give him the ability to deal with his drug use. So that would be the basis of my reasoning. I believe he's already spent the better part of this year in custody. My understanding is that he was arrested around January 3rd of this year, so he's already mostly served out his custodial sentence. Well, if Your Honor would go along with the 12 months, then he would have already mostly served out that custodial sentence. So it would just be a couple months after that, and then he'd be put back on, put into RSAT. And so that's the basis for for my recommendation, the previous drug use. That would be the end of my presentation, Your Honor.
All right, anything else, Ms. Sneed?
Yes, Your Honor, we believe that the state's recommendation is more than fair considering the total amount of drugs that Mr. Kelly had in his possession, combined with his criminal history. He does have 4 prior felonies, one of which from 2020 was a possession with intent to distribute methamphetamine, and another 2022 case for possession of methamphetamine, as well as the fact that he's apparently already been in drug court. Your Honor, we believe that the sentence recommended by the state is more than fair, and we would ask that you impose that.
You said there was a prior possession with intent?
Yes, Your Honor.
Where was that?
That was in Lumpkin County, Your Honor,
Okay.
from 2020.
You went to Kickstart, right? Were you at Kickstart, Star House?
After that, I went to Kickstart and in drug court, but for that.
All right, Mr. Kelly, man, this just kills me because I got to know you in drug court and felt like you did pretty good, but this happened pretty soon after you got out. And it doesn't seem like you learned anything. The sentence on count 1 is going to be 20 years with 5 years to serve. You'll receive credit for any time you previously served. The remainder to be served on probation. You'll pay a $2,000 fine plus court costs and surcharges. Pay the $50 PD application fee, $300 reimbursement to Hall County for your attorney's fees. You'll report to probation, perform 40 hours of community service. You'll have a 4th waiver, provide bodily specimens for testing and waive evidentiary foundations. Provide records, releases, undergo evaluation and treatment for substance abuse. Attend a minimum of 2 12-step meetings per week while you're on probation. Obtain your high school diploma or GED and show proof of that to probation. You've already got that, you just need to show proof. provided DNA sample is required by law. You'll avoid using or being in the presence of alcohol or drugs, being around others or under the influence or in possession of alcohol or drugs. Don't be in any residence or vehicle in which alcohol or drugs are present. Verify your prescriptions with probation. Be subject to a minimum of 2 drug and alcohol screens per month at your own expense at the direction of probation. Count 2 will be 5 years on probation consecutive to count 1. Count 3 will be 12 months to serve concurrent. Count 4 will be 1 day to serve concurrent. Count 5 will be a $25 fine as a special condition of count 1. And count 6, possession of a firearm by convicted felon will be 5 years to serve concurrent.
This is not the shitty case. I was wrong. I think what this one was, he had a chance. He had drug charges, I think, and then he went to drug court. This judge does drug court, but he does not stream it. He does not stream it. It's fine. We'll live. And then 2 days after he got out, I think 2 days, he was busted selling marijuana, I think. But don't worry, there's a shitty case coming.
Current. Well, I ask that
Thought
you
it
be
was him.
considered for REACT court. So perhaps that you can circle around to there. Yes, sir.
Would that be RSAT?
No. So REACT court, you'll end up going to the system, but then as soon as you get a 10 parole month, hopefully you'll be considered to come back and be at the Hall County CI, and they have an RSAT type program there at the CI. So I can't sentence you to do the REACT court program. All I can do is recommend that you be considered, and I think you're a good candidate, so hopefully they'll pick you up. But I mean, I had 2 reasons for imposing this sentence. One is because it's your second possession with intent, and the second is because you had a gun, and can't do that. Yes, sir.
Okay, so I've been an addict. I'll be honest about that. That first possession with intent, I didn't have drugs on me. Somebody pulled up, and it was maybe a point, like not even anywhere near the ground. And I was under the influence at the time. I was on drugs, and I sold it to him. So I don't know. That was it. Kind of goes back to like in a couple years ago when I first got arrested for misuse of a telecommunicational device. I didn't have any drugs on me, and I was actually I was living the wrong way at that time, around the wrong people, and I was doing things I shouldn't have been doing, hanging out. You know what I mean? But I really I did learn. I learned a lot from drug court. I'll be honest about that. I do feel that I should have stayed in Kickstart a little while longer after I graduated, just to, you know. I do feel that, and I know I should have thought about the fact about my daughter, and you know, my aunt being an elder and sick at the same. I should have thought about that ahead of time, but I learned, and if I could be a candidate for RSAP, if I mess that up, I'll go do 20 years. Like if I could just have this, I've prayed about it, and I'm asking you if I could just have this one chance to do RSAP. I know you give me chances before. But
Mr. Kelly, I mean, it kills me, man. I know you. I've known you for a long time, and I think a lot of you. But you keep finding yourself in this situation. And I do think that if you can get in REACT court, that'll provide an avenue for you to continue to get treatment, an RSAT type program at the CI, so you'll be local. I just can't sentence you to it. All I can do
Hedwig, thank you.
is recommend you. But, you know, sometimes this got to stop. You can't say, well, I'm just an addict when you keep committing new offenses. So, I'm sorry. That's going to be a sentence. I wish you luck. All right. Mr. Sebastian, will you make sure?
All right, we're running out of 10 months. Yes, Hedwig, thank you. We're rapidly running out of time, and I need to get to... Is this it? This one. I think that one was it. Hold on, I'm just gonna double check everything. Yep. This one. This is the case. I think. Oh! Oh! I stopped it at the right part. That never happens to me. I want to thank my mom and everybody here for helping me get to this day. Sorry.
We're here on State versus Natariq Shante Sarunte Glenn, 12 CR 664. Mr. Glenn was convicted of attempted armed robbery and false imprisonment, 10 counts, and sentenced thereon. So allegedly violated condition number 1, and they committed subsequent offense of receipt, possession, or transport of a firearm by a convicted felon or felony first offender, and display of a license plate on or about 3/12/25 in Coweta County, Georgia. And a firearms violation, unlawful to possess or purchase a firearm, including a rifle, pistol, revolver, or ammunition. And that defendant was found to be in possession of a firearm on 3/12/25 in Coweta County, Georgia, resulting in subsequent offense of possession of a firearm by a convicted felon or felony first offender. And I think this is a conditional discharge, first offender.
I think this is the wrong case, but this is it. We're going to watch this case and then we're going to end the stream.
Petition to adjudicate and impose sentence. All right, and does Mr. Glenn admit or deny the allegations?
I admit.
All right, state have a recommendation?
Yes, Your Honor, probation's recommendation would be to adjudicate guilty due to the new offense and for 2 years to be revoked into the state prison system. And of course, he received all credit for all term, the sentence that he served since sentencing.
All right. Mr. Surratt?
Your Honor, we would ask the court to consider a different resolution. I just have 2 witnesses. They're not going to take that long. And Mr. Glenn would briefly like to address the court, if that's all right with the court.
That's fine. Call your witness.
Come on up. I'm going to call his mother to the stand first, Judge.
All right, you want to swear her in?
Can you please raise your right hand? Do you swear or affirm that the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can have a seat.
And Judge, I know we heard from both of these witnesses last time. I don't know if this is something we can maybe just proffer.
I'll try to bring out what was not mentioned in the last hearing, Your
Okay.
Honor.
And may have to remind me too, sir.
Sure. Would you state your full name, please?
Pamela Glenn?
Ms. Glenn, are you Notorious mother?
Yes.
Okay. And you were here last time, I believe it was on September 2nd, 2025, and you testified in court, correct?
Yes, sir.
And this was regarding the court deciding whether Mr. Glenn would get a bond for his probation matter, correct?
Yes, sir.
And at that time, you had mentioned that your son had some mental disabilities since a young age, correct?
Yes, sir. He was born with, yes.
And you wanted to have some time to kind of get some information about that and have more information for the judge at this time, correct?
Yes, sir.
Can you tell the judge a little bit about his mental health disabilities that your son has been suffering?
Yes. When Notorious was born, he was born early. He was diagnosed at the age of 4 and a half, bipolar 1. I have bipolar 2. Tori was not diagnosed with schizophrenia. I am diagnosed with schizophrenia. And growing up, his IEPs would tell the situation at the mind state that he was in. And I've always worked with the school and with his doctors. He was on the doctor's den. And he needs to be back under a doctor's care under the mental situation. I taught him to know that he was not different, that he could do the same, and he fought with the mental illnesses. And I asked for you to let him get some help that he need back, because he was a boy then. He was my boy, and he's a man now. And I asked for you to let him get some help as being a man.
Has he gotten some mental health help in the past?
Yes, sir.
And where did he get that help?
It was in Athens, Georgia, at Advantage Behavioral Health. That was probably about 20 years ago or a little more.
And is he considered disabled?
Yes, Tora was diagnosed disabled at the age of 4.5. I fought 3 years before I decided to put my son on the medication that they said he had to be put on, and that he would be labeled disabled with the bipolar and that. And I fought against myself. I said I wasn't going to put my son on that, but it came to where I had to let him get help.
Okay. And I know Destiny, his fiancée, is in court.
Yes, she is.
And we're going to talk about a program called Pathways, which is a treatment facility. Do you think that program would be a good placement for your son?
Yeah.
I don't know enough about Pathways. I hear them speaking about it, but no one has really given me a lot of information in court about exactly what Pathways is and what it does. I don't know if they're locked up. I think they are. I don't know if they get to earn times out in the community or their own apartment or their job or anything like that. I just don't know.
Yes, sir. We did a lot on finding out what they offer for Tory, and Destiny, which is his fiance, let me know what the programs were they would, and I agree with the one that they have and what they are willing to do toward working with him and getting him the help and the counseling he needs and the medication if he need it. But I'm pretty sure, yeah.
Okay. Is there anything else you want to talk about regarding your son?
I just want my son to be allowed to go to this program, and I think everything will work out. Everything will be okay.
Nothing further, Judge.
Any questions for this witness?
No questions, Your Honor.
All right. Thank you. You can step down. Thank you, ma'am. All right.
Judge, my next witness is Destiny Blunt. Oh.
I think she's testified previously. If you just want to remind me what she said, that's the fiance, correct?
That's the fiancée, Your Honor. She has testified previously. Last time we were here, Judge, she had not had the opportunity to go and get information from Pathways. Since then, she has done that. Do you want me to put her up real quick?
Sure, that's fine.
Destiny, come on up. Can you please raise your right hand? Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can have a seat. Can you please state your full name?
Destiny Blunt,
And how long have you known Mr. Glenn?
since 2022?
Okay. Before he got arrested, were you all living together?
No, he was living in Hogansville, Georgia,
And where do you live?
in Noonan, Georgia.
Okay. You were here last time about a month ago, almost a month ago. Do you recall talking about finding some information about Pathways?
Yes.
Okay. What have you found out since the last time we were in court?
I found out that they also, it's a drug treatment and a mental health facility where he could stay up to 7 days, and they also have other resources for him if he needs to go to another facility, depending on the evaluation once they've done it within him getting there.
And did you actually contact the personnel at Pathways to get this information?
Yes, I contacted the intake coordinator, Terrell Wayne, and then I also stopped by and spoke with Olivia Coate.
Okay. And would they have space and availability for Mr. Glenn to start the program if the judge were to allow him to do that?
Yes, they said they can take him immediately. They also stated that they could take him with any conditions as far as leg monitors, curfews. I asked about those things as well.
Okay. Prior to his incarceration for this case, he was working, correct?
Yes,
And did he work for a company called 8492 Group LLC?
yes,
And is that owner-operator Terrell Walker?
yes,
Okay. And he sent a letter saying that he would hire Mr. Glenn upon release, correct?
correct, yes,
Okay. And did he also work for Stevens Auto Body Shop?
yes,
Okay. And did Christy Stevens, the owner-manager, also agree to put him back to work once he's released?
yes.
Are these companies where he worked before he was arrested?
The Stevens Garage one was.
Okay.
And then also, he was working at D&H prior to getting arrested. He had also a job offer at Gershomer in Peachtree City. He was supposed to start March 17th, but he got arrested March 12th.
Okay. So
And I have that in my email.
Okay, so you had a job offer from that company
In Peachtree City, yes.
4 or 5 days before he got arrested?
Correct,
Or
yes.
after he got arrested?
Yes,
Okay.
March 17th was the start date.
And what was he like as far as his job and supporting his family before he got locked up?
He was really good. He worked 2 full-time jobs ever since I've known him, just like myself. I have a 5-year-old daughter named Kennedy. He's a really good role model to her. Her dad is not in her life just because of safety reasons, but he would come around and help us out around the house, put things together. Since I work from home, he would put my desks and chairs together that I had if needed, and just worked all the time and stayed out of trouble.
And the pathways that we talked about, is that in Noonan, Georgia?
Yes,
Okay. Is that on 74 Hospital Road in Noonan, Georgia?
yes.
Okay. Judge, I have no other questions. I do have the 2 letters from the employers who, I've shared this with the state before.
All right. Ms. Jackson, you have any questions for this witness? No, Your Honor. You said the Pathways is a 7-day program?
They said it's 5 to 7 days, depending on the evaluation, but they have other resources with longer care if he needs it. It just depends on what the physicians say once he gets the evaluation within 24 hours.
Okay, thank you, ma'am. You can step down.
Thank you.
Judge, no other witnesses other than my client would like to be heard briefly, Your Honor.
Okay. Now, you can just speak from right there.
How you doing, Judge Jeff?
Good.
Under the circumstances, I know I was caught with a firearm. I also understand I wasn't supposed to have one. Dealing with incarceration at a young age, last time I sat in your courtroom, I was 18. So dealing with incarceration and transitioning back into society, like a lot of things I went through while incarcerated were harder to transition to in the free world. In society. It was more like things of understanding what I had done, the reason for why I sat in your courtroom the first time, armed robbery, home invasion. We understand my rap sheet. The fear of it happening to me became an issue. And it was awful at sometimes, because it became a fear to where I just didn't feel comfortable even when I was safe. You know what I'm saying? So it's more like with nobody to talk to, like I could go to my family. I went, you know what I'm saying? We held many conversations and prayer and, you know what I'm saying, just giving it to God completely. And it works. It does work, but I still battle with it. And I never honestly had a chance, even after, like, I left in high school, you know what I'm saying, to speak with anybody who dealt with, like, similar issues. All I really want to say is I just really want to show you, like, it doesn't take prison in order for one to continue doing right. I worked 2 full-time jobs, not because I had to. I had my own place of employment. I came home from the halfway house, and me and my father, who's sitting back there, we had a conversation in the halfway house, and I told him I was gonna work 2 full-time jobs, even knowing my disability, because I felt like I could. And if they would have ever fallen on hard times, I wanted to know what I was made of as a man and what it would take in order to have to do such. Other than that, I do know I had a gun. Why I had it, Your Honor, honestly, if them people whose house I ran in would have had a gun, I probably wouldn't be here. And after working and just gaining certain accomplishments in life, obtaining certain things, the fear of it happening to me was too much at sometimes. And that's what it was. I don't have any ill intent against nobody. I don't wish to harm anyone. My main thing is I just really want you to know I'm sincere. Like, the whole stay while I've been out, no, it hasn't been the easiest just dealing with the mental aspect, but like, I'm asking you, can you give me some help? And I'm willing. Thank you.
All right, anything else from anybody else? Probation.
Your Honor, if I could, well, first, it's my understanding Mr. Glenn is a registered sex offender. So as far as the pathways is concerned, I don't know if that meets any proximity restrictions. And I wondered why Mr. Glenn, it shows in the computer system that he is. And then when I got to reviewing his sentence, it appears because of false imprisonments involved a minor. So I don't know if the court has the indictment. I took the time to read through the indictment because I was curious on why he's a registered sex offender. And I know he touched on it previously about the multiple false imprisonments, multiple people held at gunpoint, including minors, persons under the age of 14, multiple minors, which I find extremely alarming. For just a few years being released from serving a 20-10, Mr. Glenn's now found with a firearm. Probation finds that extremely alarming. I took the time to obtain the police report from Coweta County Sheriff's Department. It appears it was a traffic stop. The deputy or officer or deputy noticed Mr. Glenn moving around frantically inside the vehicle. Essentially asked him to exit the vehicle, and Mr. Glenn, while walking back to the patrol car, attempted to hide the firearm on his wheel, on his tire of his own vehicle. Incidentally, attempting to conceal the firearm. So he was charged with that offense. Again, probation's, I don't know if I've seen a case like this, quite honestly. That's why I kind of had to do a little bit of research on it, because I generally supervise the sex offender cases. I had to do a little digging to see why it's a registered sex offender case. I was kind of surprised, shocking to read the indictment. I guess I don't have a lot of these cases on probation because, quite honestly, they're probably not on probation. They're probably in the prison system, to be honest with you. The indictments, and then to get a first offender sentence after the indictment that I read seems extremely gracious to be under first offender and serve at 20, serve 10, and was actually released even earlier than the 10 years on parole, which I think is pretty generous. But again, probation's recommendation is to adjudicate guilty and to serve 2 years in the prison system.
Your Honor, may I just add one more thing? The court may already be aware of this, Judge. Mr. Glenn has been in custody since the date of this incident on March 12th, 2025. Your Honor sentenced him in 2012, and this was the first and only violation that Mr. Glenda had, including any technical violations whatsoever. And the underlying case in Coweta County has not proceeded to any indictment or accusation as far as I know. Last month, we were here, I had contacted his public defender. At that time, it was still in warrant status. And so he got a bond because the state had not.
Sovereign prosecutor. Oh man, I would love to see that. That's what I want. That's what I want for Christmas. It's all I want for Christmas. It's a sovereign prosecutor.
Moved to indict him within 90 days of being arrested, but in effect, he had been unable to get a bond because of this probation violation. So with regard to whatever Your Honor sentences him for disposition, we would respectfully ask the court to consider giving him credit from March 12, 2025.
Not sure how that works now under the new interpretation of the statutes of what credit I can give him from when. His custodial time on his probation revocation. I don't know what probation says about that. Is he entitled to, if I give him 2 years, does he get credit for the time served since March when he got arrested?
It's my understanding we can't include that in any of the waivers or petitions, but we would, whatever the court would order that he get credit for time served, that's what we would include in the disposition. He has been in custody. He has been in continuous custody since the arrest.
But DOC doesn't give him credit for that time on the probation revocation, right? I mean, it goes to credit towards his overall time, but not towards his custodial time, is my understanding. I think the law's in a little flux, but that's my most recent understanding of how DOC is treating revocations now. All right, Mr. Glenn, I remember this case, believe it or not. I don't think I sentenced Mr. Glenn. I was looking at the sentence. Looks like Judge Jerido sentenced him, but I sentenced some of his co-defendants, and it was a negotiated plea. I mean, the state negotiated that plea, and as I recall, there was a bunch of stupid kids that broke into somebody's house, and there were a bunch of kids at the house with, one adult, and they thought there was money there or something, and there wasn't. I'm going to adjudicate Mr. Glenn guilty and re-sentence him on count 3. I'm going to re-sentence him to the original sentence, but I'm going to revoke an additional 12 months to serve in the Hall County Jail or wherever the sheriff may direct, and he'll start getting credit on that as of today. So he's got 12 months to serve, and upon his release, he will avail himself of treatment at Pathways in Newnan, and he will follow through with any mental health treatment as recommended by his treating physician and by Pathways. So, got to go to Pathways. If they recommend you go to like a halfway house or a day program or anything like that, you got to follow through with that treatment. And if a doctor says you need to take medicine, do those things. I think under this sentence, you would serve the 12 months here in Hall County, perhaps not go back to the state system since it's 12 months starting today. And that's the way I read the Department of Corrections policy now. Mr. Glenn, I believe you. I believe you that sounds like you're suffering from PTSD, kind of reverse of what happened when you were a kid, and now you're scared, but you got to do something different. You can't have a gun, you can't have a knife. You got to deal with your fears some other way. You can't have a weapon. Yes, sir.
In my defense, this time has been a lot different. During my stay, these 6 months, I've been locked up. Like, I can't speak for everybody in here, but my journey been my journey. So like giving it to God completely has shown me if I can be okay in here around maybe what the world has the worst to offer with no knife, no gun, I can surely be all right out there.
Yes, sir.
Well, thank you.
Well, I'd encourage you, when you get to Pathways, that you talk to them about your reasoning behind why you had a gun and that sort of thing, because it really does sound like that's something you need some therapy to help you deal with, all right?
Yes, sir.
All right.
Judge,
So-
may I make one inquiry, Your Honor?
Yes.
Very briefly. Would the court consider giving him any, he's been in Hall County Jail for almost 2 months since he was transferred from Coweta. But I understand that court's credit.
I'm just saying, Department of Corrections can give him whatever kind of credit he's entitled to get. My understanding is he doesn't get any credit until a revocation order's put in place, is my understanding. It's kind of confusing right now. I don't know. Different facilities have interpreted it different ways. Quite honestly, my goal is that I don't think Mr. Glenn necessarily needs to go back into the state system. I'd rather him serve his time local. And then, you know, the punishment part of that is serving his time and then getting out and dealing with his mental health issues, going back to work, you know, working with your fiance, doing the things you need to do and staying out of trouble. And, you know, you'll either do it or you won't.
Thank you, Judge.
All right. That'll be the sense of the court. And it's fine.
Whew, okay. We did it, guys. We did it. We had a good stream. 0 days. Josh, you missed the beginning of the stream, Josh. We have to reset the timer back to 0 days. I need to put a sign right here of it's been X days since I fucked up my mute button, which would be 0 now because we started the stream muted. Alright, I'm gonna set up OJ. Oh man, what a day OJ was yesterday. Holy cow. Holy cow. I think the defense is about to start. We're getting so close to the Dream Team starting their presentation, but the Dream Team scored huge yesterday. Huge. It sucked. I'm going to start OJ now so that we can torture ourselves a little bit more. I'll see you all again. Thank you so much for coming out, guys. I appreciate it. I really, really appreciate it. Bye.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator. She's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright. She's got that grace. Come join the fun. It's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new, Oh, Kathy's the creator, she's leading the way. At court vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see